Your H-1B application could get rejected this year, not because of your qualifications, not because of your employer, but because of a new rule, and most applicants have no idea it exists. If your lottery selection date is after April 1st, 2026, you need to watch this entire video. Let's get straight to it. USCIS, that's the agency that handles your H-1B, has introduced updated compliance requirements that go into effect April 1st, 2026. This is not a small update. This changes how applications are reviewed, what documents you need, and what can get your case denied. Here's the simple version. USCIS is now doing stricter checks on 3 things. Number 1, the employer's ability to pay your salary. Number 2, the specialty occupation requirement. Number 3, the worksite and job location details. If your application is weak on any one of these 3 areas, it can get rejected, even if you were selected in the lottery. But here's the problem. Most people think, I got selected in the lottery, so I'm safe. That is wrong. Getting selected in the lottery just means you get to apply. It does not mean your visa is approved. After April 1st, USCIS is going to look at your petition more carefully than before. Let's break down each one. Simple and fast. Area 1, employer's ability to pay. USCIS wants proof your employer can actually pay your wage. This sounds basic, but here's what's changed. The officer reviewing your case now has more authority to question this, even for large companies. What do they want to see? Tax returns, financial statements, annual reports. If your employer is a small company, a startup, or a staffing firm, this scrutiny is even higher. If your employer cannot clearly show the money, your case gets an RFE. An RFE means a request for evidence. It slows everything down, and if you don't respond correctly, it becomes a denial. Most people don't know this. A lot of H-1B petitions get denied not because of the worker, but because of weak employer documents. Your job? Make sure your employer's attorney submits strong financial proof. From day 1. Area 2, specialty occupation. This is the most common rejection reason in 2026. USCIS wants to confirm that your job truly requires a specific degree in a specific field, not just any bachelor's degree, a degree directly related to the job. For example, if you're applying as a software engineer, your degree needs to connect clearly to software or computer science. If you have a business degree but you're doing IT work, USCIS may question it. If your job title is vague, USCIS may question it. This is where people get rejected. The job description in your petition needs to be precise, technical, and directly tied to your degree. Generic job descriptions will not work anymore. Area 3, worksite and location. This one surprises a lot of people. If you work at a third-party location, meaning your employer sends you to work at a client's office, USCIS wants clear documentation. They want to know, where will you work? Who controls your day-to-day work? Is there a real job waiting for you on April 1? If your employer is a consulting company or IT staffing firm, this matters a lot to you. USCIS has been cracking down on speculative employment. That means employers who file for workers before they even have a confirmed project. After April 1st, this gets stricter. If there is no confirmed work assignment with a real client, your petition is at risk. Let's be specific about who needs to pay the most attention right now. Group 1, IT consulting and staffing workers. If your employer places you at client sites, you are in the highest risk category. USCIS has always been tough on this group. After April 1st, that scrutiny increases. You need a confirmed client letter showing where you will work, what you will do, and how long the project lasts. Without that letter, your attorney is building on sand. Group 2, people in cap-exempt to cap-subject transfers. Some of you have been working at universities or nonprofits under cap-exempt H-1B. Now you want to move to a regular company. This requires a new petition under the regular H-1B cap, which means going through the lottery. The new scrutiny applies to you too. Your job duties need to clearly qualify as specialty occupation at the new employer. Don't assume your old approval carries over. It doesn't. Group 3, extensions and amendments. This is not just for new applicants. If your employer is filing an extension or an amendment, a change in job location or duties, after April 1st, the same strict review applies. Some employers try to quietly change job duties without filing an amendment. That is a compliance risk now. If USCIS discovers your actual job doesn't match your petition, they can issue a notice of intent to deny. But here's the problem. A lot of workers don't know what their petition actually says. You never saw the documents your employer filed. This is your visa, your life, your career. Ask your employer's attorney to share the petition details with you. You have the right to know what was filed on your behalf. Let's talk about what happens after you file. USCIS is expected to issue more RFEs this season than in recent years. An RFE is not an automatic denial, but it is a warning. It means USCIS looked at your case and said, "We need more proof." You then have a set number of days to respond, usually 87 days. If your response is weak or late, it becomes a denial. Here's what triggers RFEs most often under the new rules. 1. Vague job descriptions. 2. Degree doesn't clearly connect to the job. 3. Employer financial documents are missing or outdated. 4. No client letter for third-party placements. 5. Salary offered is below the prevailing wage. Most people don't know this. The prevailing wage is the minimum USCIS expects your employer to pay based on your job and location. If your offered salary is below that number, your petition has a problem. Check the Department of Labor's wage database. Search your job title and your work location. Make sure your salary meets or exceeds the level 1 wage minimum. If it doesn't, talk to your attorney before filing. Okay, let's talk action steps. These are practical things you can do, starting today. Step 1. Talk to your employer's attorney. Don't wait for them to come to you. Contact HR. Ask to speak with the immigration attorney handling your case. Ask them directly, "Is my job description specific enough? Do we have a strong specialty occupation argument? Are our financial documents updated?" If you're a third-party placement, ask, "Do we have a signed client letter?" Step 2. Review your own degree. Get your transcripts and your degree certificate ready. Make sure your immigration attorney knows exactly what you studied. If your degree field doesn't perfectly match your job title, there needs to be a strong explanation in the petition. This is called a course curriculum analysis. Ask if this was included. Step 3. Check your prevailing wage. Go to the Department of Labor's Foreign Labor Certification Data Center website. It's public. It's free. Search your job title and location. Check what wage level 1, level 2, and level 3 look like. Your offered salary should be clearly above level 1. Step 4. Get your own copy of your petition. This is important. Once your employer files your petition, ask for a copy of the I-129 form and the support letter. Read it. Does your actual job match what's described? If something is wrong, now is the time to fix it, not after an RFE. Step 5. Use premium processing if you can. Premium processing costs extra, currently around $2,805, but it guarantees USCIS will act on your case within 15 business days. If they issue an RFE under premium processing, you still have to respond, but you'll know faster. For people who need certainty before starting a new job, premium processing is worth it. This is where people get rejected. They file, they wait, they get an RFE in month 3, they respond slowly. The attorney's response is weak. Case denied. Don't be that person. Quick update on where we are in the process. The FY 2026 H-1B lottery registrations have closed. If you were selected, USCIS has notified employers through the online account system. The petition filing window opens April 1, 2026. From April 1st, your employer has until June 30, 2026 to file your petition. That is a 90-day window. Here's what the timeline looks like. Now through March 31, prepare documents, employer financials, client letters. April 1st, petitions can start being filed. April through June, main filing period. Summer 2026, USCIS processes and issues approvals or RFEs. October 1st, 2026, H-1B employment start date for CAP subject cases. One more thing that's changing. USCIS has been updating its policy manual on a rolling basis. Some of these updates affect what specialty occupation means in practical terms. USCIS adjudicators now have more flexibility to deny cases where the degree is only broadly related to the job. For example, a general business administration degree for a financial analyst role may no longer be enough on its own. You need a clear, direct connection. Make sure your petition makes that connection in writing, clearly, specifically. Here's the summary. Short and clear. After April 1st, USCIS is reviewing H-1B petitions with stricter standards: specialty occupation, employer ability to pay, and worksite documentation. These are the 3 areas that can make or break your case. If you are in IT consulting or staffing, pay extra attention. If your employer is filing your petition, stay involved. Ask questions, review documents. Don't just hand it over and hope for the best. This is your visa, your future. Be active about it. One last thing, if you get an RFE, do not panic. It is not a denial, it is a question. Respond fully, respond on time, work with a good immigration attorney. Many RFE cases get approved when handled correctly. If this video helped you, hit that like button right now. It helps more people find this information. And if you are navigating H-1B, green cards, or any U.S. immigration process, subscribe to this channel. We post updates every week in simple English, so you always know what's changing and what to do about it. Drop your question in the comments below. What part of the H-1B process are you most worried about? I read every comment. See you in the next video.